Nairobi.
To the courts now, where a dramatic showdown unfolded at the Milimani High Court in a case in which petitioners are seeking to collapse the Kenya Kwanza flagship medical cover, the Social Health Authority SHA. The petitioners are challenging the 104.8 billion Social Health Insurance Fund digital system, accusing the government of secrecy, illegal procurement, and constitutional violations. They told the court that the contract was null and void from beginning and should be quashed in its entirety. Catherine Muraget reports.
Yes. Mambo?
Appearing before Justice Bahati Mwamuye, Nakuru-based Dr. Magare Gikenyi and Busia Senator Kiomtata mounted a sustained attack on the controversial deal, insisting it was anchored on unlawful procurement methods, lacked public participation, and was driven by an entity with no legal authority to procure the system.
So he said that consequently, the excessively inefficient shift rollout, especially to the extent that it causing widespread confusion, service disruptions, or inequitable access, was contrary to public policy because it fails to achieve its core objectives of improving healthcare for Kenyans.
The petitioners argue that the Principal Secretary for Medical Services lacked legal standing to procure an integrated health management system. They accused the Minister of Health of entering into two unlawful contracts, both of which he said should be terminated. He faulted the procurement method used, saying it did not exist in law. Omtata further told the court that Safaricom should have been disqualified after declining the first 48 billion shillings contract. The petitioners also faulted the timing of the execution and payment terms of the 104.8 billion contract, arguing that it exposed taxpayers to payments long before any services were delivered.
Saying basically the effect of the SHIF and SHA is to restrict access to healthcare to only those who can pay the premiums. And that, for me and for the petitioners, is a concept for constitutionality, which we have raised up there.
The petitioners also raised concern about public participation, constitutional compliance, and the consortium's capacity. The petitioners argue that the multi-billion shilling SHIF contract lacked parliamentary approval, insisting it was never sanctioned by either House of Parliament.
Parliament retains the power.
However, the government mounted a fierce fight back, insisting the procurement and implementation of the system were lawful and in the public interest. Through Senior Counsel Kioko Kilukumi, the Minister of Health, its Cabinet Secretary and Principal Secretary pushed back against allegations of procurement irregularities raised by Omtata and his co-petitioners.
That Safaricom was Safaricom PLC and its consortium was not picked as a waiver or in a discriminatory manner. The ministry had taken out studies on what kind of strategic partner they need.
The government further rejected allegations that Safaricom was handpicked unfairly. He warned that suspending the SHIF digital platform would cripple the healthcare system, noting that it is currently the only integrated health information technology system linking patients, healthcare facilities, and service providers nationwide. Justice Mwamuye fixed judgment in the matter for March 12, 2026.
Thank you. So that is the conclusion of my cause list for the day.
Catherine Muraget, KTN, Nairobi.
Now,